Thank you, Mr. President. Mr. President and members, I rise to speak in opposition to Senate Bill 4, partly because it is patently unconstitutional under the Federal Supremacy Clause as clearly established in the U.S. versus Arizona case. Notably, while many have questioned its constitutionality, no constitutional lawyer or immigration practitioner testified to affirm its legality. Senate Bill 4 attempt to empower state and local law enforcement in immigration matters encroaches on the exclusive federal jurisdiction over immigration policy and law. There is a profound risk of violating due process rights, as the bill would require peace officers to engage in complex legal determinations for which they are not adequately trained. This could lead to the erroneous detention of U.S. citizens and lawful residents, an outcome that is as unconstitutional as it is unconscionable. What's more, the bill's provisions for the arrest and detention of persons seeking asylum or other immigration reliefs are deeply troubling. Under this bill, a person seeking asylum could be criminally charged before any humanitarian claims are assessed, a move that could violate international and U.S. asylum laws. The stipulations regarding the removal of persons by judges, which appear to leave no room for discretion, coupled with the logistical issues of returning migrants to their countries of origin, whether by land or by air, pose myriad practical and legal challenges. The bill does not seem to account for the complexities of international law and existing memoranda of understanding with Mexican states. It is not only legally questionable, but also poses a significant financial burden on our counties without offering the necessary state support. The creation of new offenses under this bill will inevitably lead to increased incarcerations, adding strain to our already stretched criminal justice system. The financial repercussions extend beyond incarceration to include the cost of magistration, confinement, medical expenses, and indigent defense, all of which would be borne by counties and ultimately by taxpayers. Neither fully nor partially reimbursed by the state, these costs would be unfunded mandates that counties simply could not afford. Most concerning are the potential consequences for women and children. The bill could lead to the enforcement of penalties against vulnerable groups, including the potential for family separation similar to those seen during the previous administration's zero-tolerance policy. The implications for children, whether placed in state foster care or at the Office of Refugee and Resettlement Facilities, are heart-wrenching and could have long-lasting traumatic effects. Equally disturbing, the feedback and suggestions of border leaders continue to fall on deaf ears. Previously, I distributed copies of an op-ed by Senators Hinojosa, Blanco, and me. Believe me, we are working on another one. Today, I distributed a report titled Common Sense Border Management Solutions, and members, you have a copy of this on your desk, with a letter written to me by a leading Republican from Laredo, Dennis Nixon. Many of you know him, and he has hosted in Laredo Lieutenant Governor Dan Patrick, Lieutenant Governor David Dewhurst, Lieutenant Governor Bill Hobby, Governor Bush, and many, many other leading Republicans, including United States senators. I'm not going to review it, but I hope you will read it. Clearly, for us, Senate bill is not only a legal quagmire, but also a moral one. Accordingly, I will respectfully vote no on Senate Bill 4, and again, I appreciate all who will do the same. Thank you, Mr. President and members.